Hello and good morning. This morning I have invited on Stephanie Bellchambers, who is a director at Solicitors. She is a practicing family solicitor, head of the family department, and has been working exclusively in family law for over a decade. So Steph has come on today to talk to us about financial proceedings following divorce, and in particular financial settlements amid the COVID lockdown situation that we're currently in. So good morning, Steph.
Morning.
First question for you then, is there anything you can do if you had a financial settlement approved just prior to lockdown and now you think it's unfair?
If your agreement has clauses within it that could be varied anyway, so regardless of the COVID-19 situation, and these types of clauses would be a maintenance clause or a lump sum by instalments, then those aspects, yes, could be returned to the court for the court to have a look at it. That could be, for example, if you've been ordered to pay maintenance, but you've now been furloughed and you can't afford that maintenance, or you've lost your job because of the current situation, then you can return it to the court, and likewise with a series of lump sums, so that can be varied as well if your capital position has changed. But generally, if you want to change the whole ethos of the order because of the COVID-19 situation, it's very rare that we can do that. We often refer to that as a barter event. It's a very, very rare circumstance that can happen. Lawyers up and down the country have been having a debate and mooting as to whether COVID-19 is such a barter event, because on the one hand, this situation could not have been foreseen. We did not know that this was going to happen in 2020, and it has had quite a bit of impact so far and may still be impacting in the next few weeks or months. I don't think anyone is brave enough yet to be the first test case to take that back, but it would really need to be looked at in a very detailed way. Probably not is the answer. And if you've entered into your financial agreement and consent order after COVID-19, then definitely not, because you were aware of the circumstances. So I don't think you would have a positive outcome if you tried to take it back after everyone was aware of the COVID-19 situation and lockdown.
So we have a number of clients that are already going through their divorce proceedings, and we're in the process of trying to reach an agreement. And also, I've spoken to quite a few new clients now, and I'm sure you have since the lockdowns happened. And one of the questions that I keep getting asked is, well, is this a good time to be entering into a financial settlement?
It really depends on each party's individual circumstances, what the assets are and who holds those assets. For example, we're seeing that a lot of pensions are now falling in value. So if you are the party pursuing a share of a pension from the other party, then no, this is probably not a great time, because that pension value is likely to have fallen. But if the situation is reversed, then yes, you may want to proceed as quickly as possible. But it really does depend on the circumstances. But you can try and agree things to still progress matters forward. So if there's a house, you could agree to postpone a sale if a sale is going to happen. And obviously we have to comply with the government guidelines anyway in relation to house sales at the moment. But really try and agree a percentage in terms of an equity split on a house rather than fixed figures, because you don't know whether that fixed figure is still going to be the same in a few weeks or months' time when that house may actually sell, or if you're transferring the house to another party and paying a lump sum, you really don't know whether those figures are still going to be valid in a few weeks or months' time. So it really needs to have careful consideration.
Perfect. And if clients can't agree, still in this sort of situation, can they still make an application to court at the moment?
Yes, absolutely. But obviously what we would suggest in the first instance is to try and agree outside of the court arena if you can. So communicate between yourselves as much as you can. Communicate via your solicitors, have some negotiations. And also, as we would suggest in most cases, go to mediation. It's often the quickest and cheapest method and most amicable to try and reach an agreement. Plus, as we know, mediation is part of the pre-action protocol. So you must have tried mediation before making that application to the courts. But if all of those avenues have failed, then the court is there. The court is open. We are still having hearings. They're being held remotely, but the court is still there, so you can still make that application. The court will then order full financial disclosure from both parties and timetable the case through to help there be a resolution.
And when you say the court's working remotely, in your experience at the moment, how is that happening practically?
Well, we've all had to get up to speed quite quickly in using all of these various new IT techniques, so Zoom and Microsoft Teams and all of those things, and the court has had to come up to speed quite quickly. So everyone is working so hard to make sure that hearings are going ahead as normally as possible, normally. So our hearings are remotely. Most of our hearings that we're having in the family department, private family department, are by phone. There's pros and cons, but the biggest advantage obviously is those hearings are still going ahead and those clients aren't experiencing delays. Some hearings have had to be postponed, but the court is working as hard as possible to get those dates back in the diary and to keep cases moving. But by and large, they're working well.
Perfect. Well, thank you very much for coming on to speak to us this morning, because I know that you're really, really busy.
Fine.
It's been a pleasure.
Thank you.
Take care.
Thank you.